Hey guys, good morning. Just one public service announcement before we start.
Good morning, guys. I'm Emily. I'm from the University of Auckland's Chinese Law Club. Just letting you guys know that we have our contract law workshop on this Thursday, and that'll be in the Science Building, room 101. We've got 2024's top student actually teaching this workshop, so it'd be good to come along and get some insights from him. Just go to our Instagram, Chinese Law Club UOA, and register there, because for our past 4 workshops we've actually capped out. And if any of you guys are also taking torts, so there's the torts workshop tonight, and that's in Gen Library, B15. And these all go from 6 o'clock to 7:30. So thanks, guys.
Open to everyone? Open to everyone?
Yeah, open to everyone, of course.
Yeah.
These are open to everyone. Don't have to be Chinese. Thank you.
Great, thanks, Emily. Morning, everyone. What we're going to do today is finish implication of terms, and then I'm going to give you a broad overview of interpretation, because I think actually that's an easier way of grasping it, or a more useful way of grasping it, than getting into the weeds of the individual cases, although I have given you quite a few weeds in the slides anyway, so you can satisfy yourself with those yourself. We won't go through them in class. However, before I start that, I actually am going to give you 5 minutes now, and I want all of you who are on your laptops to go to the Canvas page and fill out the set report. After my pleading last week, you've gone from 1 to 5%, which is a 5-fold increase, which sounds good, but 5% is not great. So let's see how many percent we can get it up in the next 5 minutes. I'm going to have a competition between this group and the group at 3 o'clock to see who can bump up the percentages more. So we're starting at 5%. Let's see what we can get to in the next 5 minutes. Where is it? It's a good question. Let's show you where it is. Law of contract. Oh wait, go to hopefully you can see the tab there, set evaluations on the side. Okay, so 4 more minutes. I am officially leaving the room, so you're not feeling pressured by me. 2 more minutes. One more minute. Oh, well, that's not bad. Well, it's still pretty bad. But we went up 6% then, so that's good. We'll see if the second stream can do better. I assume those who didn't fill it out are still thinking about the pages of responses that you want to give me. That's fair enough. But no, please do, if you haven't managed to do it then, please do, if you get a chance, spend a couple of minutes filling out that set report. As I say, we really appreciate it, and we do read all the comments. Great, okay, thanks everyone. We're obviously in the last week of class. Exams are, well, sorry, exams, I don't care about the rest of them. Contract exam is 3 weeks away. So just be aware of that, 3 weeks on Monday. And I hope all the study and catching up and preparation for that is going, that it's going. Okay, so we're going to finish today implication of terms, and then we're going to look over interpretation broadly to give you a sense of the debate and where at least New Zealand is at the moment when it comes to interpretation. And then on Wednesday, I want to use that time to go over question, I think it's 4 from last year's exam. I will post the question on the announcement, so please do look at that prior to class. We will do that in class together. That's a terms question, an incorporation question. So we'll do that together to round out incorporation of terms. And then any further questions that you have about the course, about studying, and particularly about the stuff that I've taught, please bring them on Wednesday to class and we can go through them together. The reason why it's great to have questions in class is because then everyone else gets the benefit of the answers to your questions, and often people have similar concerns, questions, misunderstandings. So it's much more efficient for me to answer them in front of everyone and recorded for all time for everyone else who's not here. Okay, so that's the plan of attack for the last week of class. We were looking at implication of terms on Wednesday, which seems a long time ago. And remember, we were talking about when the court will say that there is a gap in this contract that should be filled by a term that the court, in the end, is writing and enforcing on the parties. And that there is good reason sometimes to do that when the contract clearly needs a term implied in, because there is a gap. But we also discussed how doing so by the courts is dangerous insofar as it's not expressly what the parties agreed to. And the whole point of contract law is to enforce obligations that the parties have agreed to. And so to impose obligations on by the courts on the parties is contrary to the very nature of contractual obligations enforceable at law. And so the courts will only do so when a very high threshold is met. The case that we first looked at was an example of when the courts were asked to imply in a term because everyone in the industry or the trade knew that when they entered into contracts, this term went without saying. It was part of the background of the negotiations. You didn't need to put it in expressly because everyone knew when you contracted in this way or in this industry, this was the obligation that everyone knew existed. And so in that case, in Woods and Ellingham, the question was whether a term should be implied in to put the risk that the ground turned out to be abnormally hard to work. There's a drainage contract. The risk then is placed on the landowner, and they are to tell the contractor prior to contracting that the ground is abnormal and that therefore it's going to cost more money and take more time. And if they don't tell the contractor, then any extra costs are borne by the landowner and they have to pay more to the contractor. That failed because simply the contractor seeking to imply that term in failed to give good evidence that such a term existed. And again, the court said it's a very high threshold. You need to show good evidence that this exists in the industry, and so you need to bring in witnesses to attest to that term, to give examples of when that term has been used in their own experience. And quite simply in this case, they failed, the plaintiff failed to do so. Okay, so that's an example of how the courts apply the trade usage implication question. We're now going to move on to some cases which aren't based on trade usage, but instead based upon the words of the contract between the parties and the fact that the contract either requires by implication this term to be placed in, or there's a gap that needs to be filled by implication. So the first case, Liverpool City Council, was about a multi-level tenancy owned by the City Council. And over time, and then the tenants lived in it, over time the common areas, that is the stairwell going up, the lifts, and the rubbish chute became degraded. The flats overall were run down, they were vandalised. The rubbish chute was frequently blocked and the lifts didn't work. And the defendants got so sick of this that they withheld their rent. And the plaintiff, the council, sought to evict them for failure to pay rent. And the defendants said, no, because your failure to keep up the common areas, we should get damages, which at the very least counteract any rent that we have failed to pay, and also an injunction preventing you from kicking us out because you, the landlord, have failed to uphold your obligations. The trouble was there was no obligation on the plaintiff, the plaintiff council to do anything about the common areas. In fact, the contract placed no express obligations on the plaintiff at all. So the only way the defendants were going to win is if they could show that there was a term that should be implied in to give them quiet enjoyment, which included necessarily some standards of maintenance of the common areas. Now, the starting point that the House of Lords goes through is the contract itself, which we talked about on Wednesday. Is always a very good place to start. What are the documents that make up this contract? What obligations can we take from it? Well, essentially there was just one document, which was a document that the tenants had to sign when they entered into their tenancy. So it was just a list of obligations entitled Conditions of Tenancy that the tenants had to sign up to. On the other side, there were no obligations, no signature, no covenants, no anything on the part of the council. So on the written documents, there was nothing. Well, that's not a contract, that's a one-way, set of obligations. But obviously, the parties intended this to be a legally binding contract with obligations flowing from both parties. And so the courts very easily said, look, this is a partly written contract, but it's partly something else. Probably not oral, but there is an expectation which is backed up by the parties' actions that the council has obligations as well. The most obvious is that the council grants the tenants possession of the flats. They gave them a key, they allowed them to stay there without getting kicked out. Clearly the council granted them possession. So we can imply in that to make this a bilateral contract, we need to imply in the idea that this obligation that the council would give possession of the flats. And we're also going to imply in that the common areas were not owned or in the responsibility of the tenants, but were reserved as the responsibility of the council itself. It's the only way it could make it work. Okay, so the common areas are reserved. The council has to give quiet enjoyment. That doesn't help the defendants much. We need to go further than that. We need to imply in that not only are the common areas the responsibility of the council, but that there's some obligation to keep these common areas in some sort of upkeep, which was then breached. So, what do we imply in? Well, the courts make this interesting observation on the spectrum of implied terms. Again, this is another approach to trying to divide up implied terms cases, another way of categorising them. The House of Lords said there's 4 points. You've got a complete contract with implied terms by usage or custom, the Woods and Allingham situation we talked about. Where you have an apparently completed contract, but you have implied terms in to make it work in the real world. So that's the Moorcock example, which we're going to look at very soon. There's what Master of the Rolls Lord Denning implied in this case in the Court of Appeal before it made it to the House of Lords, which is we'll imply in reasonable terms as judged by Lord Denning. And finally, when the parties haven't provided everything expressly, when you need to imply in terms to fill in those gaps, which the court said is what's happening in this case. Clearly, it's a one-sided contract on the written documents. You need to imply in obligations to make it work. So, the court says 3 of those parts on the spectrum are valid, 1 is not. Guess which one is not valid? Which one do you think the courts wouldn't? Yeah. Probably Lord Denning's. Why is that?
I think implication of reasonable terms sets the threshold to it could mean that the court's putting towards the parties bound.
Yeah, that is a recipe for the judges to write in what they think is right or just, but that's not what contract law is about. It's what about the parties actually agreed to. So the court strikes that down. We're not going to imply unreasonable terms. That is not what the court's role is when we're implying terms. In this case, there clearly must be an implied right that the tenants have to possession and quiet enjoyment. That's the fundamental right that you get when you rent a tenancy. Furthermore, in order to access your tenancy in a multi-level building, there must be an implied right to use the staircase and the lift, as well as a right to use the rubbish chutes. But what obligation relies upon the landlord to keep up these common areas, the lifts, the stairwells, and the rubbish chutes? Is there nothing beyond ensuring that the tenants aren't injured using the stairwells, the lifts, and the rubbish chutes? Is it a bare minimum of safety? We'll do everything reasonable to ensure that no reasonably foreseeable injury will occur to you when you use these common areas. That's what the council argued. And the defendant said, no, there's something more than that. You need to maintain them so that they can be used, not just that they're safe. The court says, look, the test, again, is one of necessity. What does the contract require to make it work? In this case, the stairs and the lift and the rubbish chutes were the essential requirements of this tenancy working. You can't have a multi-level tenancy when the common areas don't exist or can't be used. So there's some contractual obligation on the landlord. The court says this isn't about business efficacy, but from the very nature of the relationship itself. Here, there's an essential means of access which remain in the landlord's occupation. They're reserved to the landlord. And therefore, unless some sort of requirement of upkeep is placed upon the tenants in the contract itself, the nature of the contract requires that the landlord keep these stairwells and stuff maintained. That makes sense. If you're keeping control of them, it makes sense that you are the one who must keep them maintained. So the question is, what standard must it be maintained to? The court says an absolute obligation to repair. So to keep it so any derogation from the absolute standard of these are always working would be unreasonable. You don't always have to keep the lifts or the chute working or the chutes unblocked. That would be unreasonable. But instead, the standard is that the landlord must take reasonable care to keep these in reasonable repair and usability. And it had been held at first instance, the judge had gone and seen the tenancy, that actually in this instance the landlord had not breached that requirement. It's not entirely clear from the judgment why that was the case, but there seems implicitly to be a finding that a lot of this damage and unusability of these common areas was due to the tenant's own action. As a collective. We don't know who actually did it. So the court says, look, the landlord's doing everything they should, do everything reasonable to keep these maintained. They haven't breached their standard. And so the plaintiff wins, the council wins. So what do we take from this case? Well, firstly, that a term, or many terms, were implied into this contract. Why? To make the contract work. Because otherwise you just had a wholly one-sided relationship, which clearly cannot be what this contract consisted of. Furthermore, the term requested by the tenants was implied in, again, because it just makes sense from the relationship itself. Who has control over these common areas? The landlord. Therefore, the landlord has some contractual obligation to keep them repaired, just on the facts that obligation was not breached. Make sense? Happy? well, something similar, do sing out if there is a problem, but something similar was happening in Vickery and Waitaki International, where you have the courts again implying a term in, essentially to make it work, but again, here they start with the words of the contract, and it's not nearly as clear as in Liverpool that there are gaps in the contract. Clearly, there are gaps in the contract in Liverpool. There are not so obviously gaps in this case in Vickery and Waitaki International, but the courts imply the term in anyway based on the rest of the express terms. So here you have a freezing works where the plaintiff was contracted to provide catering and cleaning services. So there was about 300 employees. They needed to be fed, or at least there needed to be the option for them to be fed. So he was contracted to provide catering services. So effectively to run some sort of cafeteria, and also to clean the hostel for those who were living on site. And then in the 80s, about halfway through, this was a 3-year term and it had rights of renewal for another 6 years. About a year into the term, there was a dispute between the workers and the management locked the workers out. So this wasn't a strike, this was a lockout. So the managers were the ones who brought the work to an end. And so with 3 years to go, the lockout was not resolved and the managers closed the freezing works. There was no employees, so there was no need to clean the hostel, and nor was there any point in having the cafeteria open. But if you don't have an open cafeteria, you obviously can't sell anything to anyone, and therefore you're not making any money. So the plaintiff sued for compensation. You shut down the freezing works. I had 3 years left to go on this valuable right to run a cafeteria. I can't run the cafeteria anymore because there's no one there, there's no point. I've lost money, therefore I'm suing you for compensation. On what grounds? On the grounds that there was a contractual obligation on you to provide a freezing works number of employees as a potential buyer base for my cafeteria. At the High Court, the plaintiff was successful in being awarded compensation for the cleaning part of the agreement, but dismissed the claim relating to the cafeteria. Effectively, the defendant was not obliged under the contract to provide a workforce. Now, clearly, there was no express term that said, during the term of this contract, we will provide a workforce for your cafeteria. So the question is, should a term be implied in or read in along those lines? The High Court level focused very much on this idea of whether or not the term was needed for business efficacy. And the court said, no, it wasn't needed for business efficacy. This contract works perfectly fine without this implied term. Essentially, the risk was on the cafeteria owner that the freezing works might shut down. And therefore, we don't need to imply a term in. And we should not imply a term in. But at the Court of Appeal level, the court's argument, or the court's focus, was directed far more upon the express words of the agreement and whether or not those express words implied in this requirement for a workforce. And the Court of Appeal said yes, it did. Now, the argument was run that that's ridiculous. How can we, as the managers of this freezing works have an obligation to keep our freezing works open and therefore a workforce, no matter the commercial viability of our freezing works, just so this guy can provide catering services. That's commercially absurd. And what, you're saying that if we breach that, we're going to have to be forced by an order of specific performance or an injunction to keep these employees on site, even if we're losing money and will go bankrupt. And the court said no, that's not the outcome that would happen. Specific performance is not granted as of right. It is it's a discretionary remedy. We would obviously not specifically enforce an obligation to keep the freezing works open or employees employed or the business running. But that doesn't mean the failure to do so can't be a breach of a contractual obligation, which gives rise to damages. For example, when a company is wound up or goes into liquidation, employees have a contractual right to be paid out their notice period. No one is granted a specific performance to keep the business open for the 4 weeks of the notice period, but they are paid out. And that's exactly the same here, or analogous at least to here. You don't have to keep the freezing works open, but if you choose to close it, you have to pay out your workers, and you also have to pay out this guy who has a contractual right to have a cafeteria that has at least potential customers. Okay, so it looks at other cases, refers to Irving. The express clauses that were relevant was the fact that there was clearly references with that throughout the contract to the works, i.e. we're providing a cafeteria for the freezing works, or sometimes a reference to the freezing works employees. Furthermore, it was clear that the appellant was to gain a valuable right by having this 3-year term of cafeteria. It was clearly meant to be a valuable right. It can only be a valuable right if you've got someone to sell to. While the appellant had the risk that there might be work stoppages, so there might be strikes in which the workers go off for a day or two or perhaps a week, being locked out and then the freezing works closing down was clearly a risk of an entirely different magnitude, which was not one that the appellant took in the contract. So looking at those express terms and the overall purpose of the agreement, there was clearly, the court said, a term that should be implied in that the company was to provide a workforce. And as I say, it was the court found it quite obvious. Now again, they made it clear the company could close the works if it wished to do so, but if it did, it still was liable in damages for breach of this implied term. The implication of this term did not require them to keep the company going, no more than it requires a company to keep going just because it has employees that it has a contractual right to pay a notice period to. But the point is, if you do close down, you are liable in damages to the plaintiff. And so therefore the plaintiff won. There was an implied term put into that contract. Why? Because of the nature of the agreement itself and the express terms. Again, there wasn't a gap necessarily that says this just does not work without a workforce being provided by the owners of the freezing works. And indeed, the contract could quite easily work and say the right was a very contingent one to provide a cafeteria, and there was no guarantee that from day to day you'd have any employees of the freezing works to sell to. But that was not the contract the court held was entered into. Instead, it was very clear meant to be a right over a number of years. That implied in that there was going to be people to sell to. And so again, without much difficulty, the Court of Appeal implied this term in. Again, not to give business efficacy, but because the express terms of the agreement naturally flowed from those express terms. Yeah?
What were the damages
Yeah, for the term they had to pay about 25 grand or something, which is not insignificant. It would have been based, I imagine, on the previous earnings that they'd made, like profit that they'd made over the last, with that particular workforce. Yeah.
If it was like a 50-year contract,
Yeah.
would they do the same decision? Or would there be a point where it becomes unreasonable?
Interesting question. What would be the argument to not pay him out for 50 years? So I have a right, say it's the same, but it was a 50-year term. I have a right to a cafeteria, and I've paid for that right. Presumably 50 years would be quite a valuable thing. So I've paid for the right to have a cafeteria here for 50 years. Why should my right be reduced just because I got a very valuable right? I suppose would be the argument I'd run as the plaintiff. So I don't think it should make any difference. Even though the damages are very large, that's what the plaintiff and the company agreed to. On the other hand, of course, the damages would be reduced to take into account you're getting the damages all at once today rather than over a 50-year period. So there's always that reduction of damages to take into account you're getting a lump sum today rather than periodic payments over 50 years. But yeah, I don't think in principle there should be any difference. Yes, up the back.
What about in this case, they said that there wasn't the risk of the work closing down, there was just like them leaving and stuff. But if it was for a contract for 50 years, isn't there a greater risk of the work?
Fantastic. Okay, so the argument is actually the risk allocation analysis changes when it's a 50-year contract. So 3 years, it's a shorter time frame, there's less risk of it shutting down. Yes, I can see that argument being made. The question is, would it succeed? Perhaps. It would depend, I think, on how much he'd spent for that right to have a cafeteria, and therefore were there any discussions around that right? I mean, it's a little bit hypothetical and arbitrary because I just can't imagine anyone agreeing to enter into that. But yes, I think that would be the best argument for the freezing works managers, and that's a really good point. Thank you. Yeah, so you'd be saying, actually, because of the risk analysis changing, we shouldn't imply the term in at all. Yeah. Or at least it's time limited or something. Yeah, good questions. Any other questions at all? Okay. I want to move on relatively quickly because I do want to get through today the rest of the course. The moorcock. It's one of the most it's one of the seminal implication cases, and I will indulge some of my artistic skills for you to demonstrate what happened. If I can find a blank piece of paper, which I can't. What happened in the moorcock? Okay. Can you see? Great. Okay. So, you've got a river and a jetty. Do you know I learned that jetty, wharf, quay and pier are all different things? They are not synonyms? I can't remember what their distinctions were. But the question is whether they go out into the water. 2 of them go out into the water, 2 of them are along the shoreline, and 2 of them have posts and 2 of them are solid. So that's the difference. So if you go into the shore solid, you're one. If you go out, anyway, it doesn't matter. But that's why in this case, because I was reading this case and I couldn't understand how they kept on referring to the jetty and the wharf. I was like, aren't they the same thing? No, they're not. There you go. Anyway, don't ask me what they are. I won't ask you in the exam either. But anyway, English language is fantastic. I'm so glad I didn't have to learn it. Okay. So you've got a wharf or a jetty. I think this is the wharf because it goes along the shoreline. I think that's the jetty. And then you've got a boat, which is called the moorcock. And the boat needs to use the jetty to get the goods onto land via the wharf. And in order to use the jetty, the boat has to come alongside. And rivers, this is a relatively tidal river, so the water depth goes up and down. And at low tide, the boat using the jetty necessarily had to take the ground. That is, the ground underneath, the boat had to physically rest on the bottom. Like you see mud flats where you have yachts at low tide, they're lying on the mud. The problem was that the riverbank was not like this, it was actually like this. It's very jagged, and the boat, the moorcock, took the ground and was damaged. And the owners sued the jetty owners for the damage caused to their boat. Now, the jetty owners didn't own the riverbank, so they were not in any way, they couldn't really be liable for failing to keep clear or keep safe something they didn't own. But was there some way to hold them liable in contract for damage taken by boats using their jetty? And the court said yes, there was. So berthing at the wharf, neither party knew that the riverbed was uneven, and it turned out they couldn't safely anchor and take the bottom at low tide. So the boat was damaged. The plaintiffs couldn't rely on any express term in the contract, but it had to imply in a term that the defendant would take care to ensure that it was safe to berth. And the Court of Appeal unanimously held that there was an implied term that was breached here. And the implied term was, essentially, you have the duty, you, the jetty owner, have the duty to check the condition of the riverbed and either repair it or make it safe if you can, but if you cannot, to warn any boat owner who is going to use your jetty. Which essentially is what the requirement would be, because I don't think they had the right to dredge the riverbed. Why? Because, well, who out of the two parties has the better opportunity to find out the state of the riverbed? Well, it's the jetty owners. They are there all the time. They are asking people to come to the jetty to use their facilities. They are making money from that. The boat owners have no way of checking the riverbed. They are assuming that it's safe if the only way to use the defendant's wharf, jetty, is to take the bottom at low tide. Then the assumption is, and the reasonable assumption is that it's safe to do so. And the court says, Lord Escher says, honest business could not be carried on unless the defendant had impliedly undertaken some duty re the riverbed. You just wouldn't have a jetty business if the risk was entirely on the boat owners. But what's the least onerous duty to imply in? It's to take reasonable care to find out the riverbed's condition, and then to make it reasonably fit for purpose, or to warn everyone what the condition is. Did not do so here, and therefore they broke the contract and they're liable. This case is sometimes cited as the business efficacy case. That is, the only way this contract could make any business, could work in a business sense, was to imply this term in. And that's what Lord Justice Bowen really leans into. Look, when we imply terms in, we're looking at the presumed intention of the parties, but we need to give the transaction the efficacy that the parties must have intended it to have. The business of the jetty could not be carried out without some care being taken to show it was safe. Again, the ship owner could know nothing and the jetty owner could find out about the riverbed with minimum fuss. Again, it's not an absolute obligation to ensure that it's safe, but it's a reasonable obligation to ensure that it's safe, or if they can't do that, to at least warn everyone that it's not safe to park your boat there. Okay. So again, there's not really a gap you can identify by reading the contract, but based on the real-world application of that contract, in order for this contract to make any to work commercially in the real world, you've got a tidal river, you want to use the jetty. In order to use it, you need the boats to be able to take the bottom at low tide. This is needed to be implied in to make the contract work in the real world for this particular business. So again, it's not a gap like Liverpool. It's not really based on the express terms like Vickery, but it's an interplay between the contract and the real world, and that's the only way that it can work in the real world. That's a case of the business efficacy. Does that make sense? Okay. The last three cases we're not going to go into the details of the facts. You can read them for yourself. But essentially, the last three cases, AGM, Attorney General of Belize, Marks and Spencer, and then Bathurst. The first two are the UK cases. And they are dealing with this relatively theoretical question about the interplay between interpretation and implication. In the late 1990s and the early 2000s, Lord Hoffman was a very influential judge, obviously in the common law. He was common law world. He was a law lord, and he sat on many contract interpretation cases. And ICS is the most famous, Chartbrook is another one, and then AGN Belize is around the same time. And essentially, he was advocating for a greater liberalisation in the approach taken to the interpretation of contracts as a whole. And in AGN Belize, Lord Hoffman essentially said interpretation and implication are all part of the same process of figuring out what the contract reasonably means to a reasonable person looking at it with all the relevant background information that the parties had. So I'm not going to go through the facts, but we'll skip to, we can read those for yourself. We'll skip to this slide. So His Lordship says effectively that there's very much a large overlap between interpretation and implication. You imply in a term to fill a gap in the contract after interpreting what that contract means. It's not to improve the contract, it's not to make it more fair and reasonable, but it's to figure out what the contract actually meant. And once you do that, you might say, okay, well, is the contract silent on this particular point in question, such as keeping the lifts and stairwells clean, such as the riverbed, such as keeping a workforce going? Well, if it's silent, the question is then, do we have to imply in a term? But when you're doing so, what you're doing is really construing the instrument as a whole, according to Lord Hoffman, because you're using the implied term to spell out what the contract would reasonably be understood to mean. And that, His Lordship said, is the key test. The others are merely ways of stating it. So business efficacy goes without saying, etc., etc. They're not to be given a life of their own and should not divert attention from the real question is, what does this contract objectively mean? And the BP refinery test, if you remember that, we looked at on Wednesday. I'll just remind you what that test was, if I can find it. It's in Marks and Spencer. I'll find it in a second. The BP refinery test, remember that was the 5-part. It must be reasonable and equitable, must be necessary to give business efficacy, it must be obvious, so obvious that it goes without saying, it must be capable of clear expression, must not contradict any express term of the contract. All of these are merely ways of asking whether the implied term spells out what the contract actually means. So to imply terms, then you need to interpret the document. Objectively, what does the contract mean in this situation? Do we need to imply in a term to reach that meaning? And this sprouted all sorts of academic debate and confusion about the interplay between incorporation and, of an implied term and interpretation. What we see subsequently is a reaffirmation by both the Supreme Court in the UK and Marks and Spencer and the Supreme Court in New Zealand that there was no intention by Lord Hoffman to change the law relating to implication of terms. And that although there is a link between interpretation of a document and an incorporation of a term, those two are very distinct, different things and processes. You need to interpret the document first to figure out if there are any holes in it that you need to fill via implication. And what the parties intended, what a reasonable person would think the contract would mean, is relevant for figuring out if there's a gap. But then filling that gap is a implication exercise. So I just want to, again, I'm not going to go through the weeds of Marks and Spencer, but Lord Neuberger in Marks and Spencer made 6 comments relating to BP refinery. And he first of all says, look, when we talk about it goes without saying, or what the parties would have intended when they entered into the contract, that's not really getting at what these actual parties would have said, because it's usually not very helpful to ask what would you have said at the time you entered into the contract. Firstly, because they probably haven't thought about it, that's why they didn't write a term in. Secondly, it's no point asking them now, because one party saying, I want the term implied in, said, oh yeah, of course we would have agreed to that. And the other party said, no, of course we wouldn't. So it's not really proof of actual intention of these parties, but instead what reasonable people in the position of the parties would have said at the time of contracting. It's an objective approach where the courts are really stepping in to say whether or not we think this was reasonable. Reasonable parties would have agreed to this. Fairness or reasonableness are necessary but not sufficient. And in fact, fairness and equity, or reasonableness and equitableness, which is the first one of BP refinery, doesn't add much to the test, simply because it's hard to satisfy those other requirements if it's not fair and reasonable. Business necessity and obviousness can be alternatives. You don't need to show both of them, although they both generally go together. And if you're asking an officious bystander what, someone at the time of contracting, does this go without saying, you need to be careful of the question that you're asking. And when we're talking about business efficacy, we're not talking about absolute necessity, but instead whether without it the contract would lack commercial coherence. So, for example, in the Moorcock, it was not absolutely necessary that the risk that the riverbed is not safe be on the jetty owner. It could have been on the ship owner. But that's an example where the contract would have lacked commercial coherence, mainly on the imbalance of knowledge required to know whether the riverbed was safe. And so that's what's really what you're asking about when you talk about business efficacy. So the officious bystander question is to be asked at the time of the contract being made and not with hindsight, which is always very difficult to do when you're in a court case that's come up about 6 years or 10 years after the contract was entered into and everything's turned to custard. But try not to use hindsight. Try to think about what they would have agreed at the time. But it's not just implying in what is reasonable. It's more than that. It needs to be necessary. Belize Telecom didn't change the law in this respect. Construing the words and interpreting them and implying additional words are different processes governed by different rules. You can only construe the words that are actually used, and then you can only imply in words that aren't there. You must interpret the document first, and only then can you decide whether you need to imply a term in. If for no other reason, then you need to know what the express terms are to be sure that your implied term is not contradicting them. And essentially, New Zealand, in the leading case of Bathurst Resources, has said the same thing. The Supreme Court, in this case, reiterates that New Zealand has consistently applied the 5-point BP refinery test. And at 116, as we mentioned last week, the Supreme Court said a number of things. Firstly, that implication is a high hurdle, that the starting point is the words of the contract, that you'll only imply in a term if it would spell out what the contract must be understood to mean, that it's an objective inquiry, not what the subjective parties actually intended. And finally, that BP refinery is a useful framework, but you do not need to satisfy every element. Remember, the first three overlap. And the last two, you do need to always show that it's capable of clear expression and that it doesn't contradict any express terms. So you have to show those two. But the other three, you don't need to check them off. It's not a test in that respect. It's a framework. Okay. So it's quite clear in New Zealand and the UK that interpretation comes first and then implication comes second if we need to for business efficacy, not just because the term is reasonable. Think about what objective parties would have thought at the time they were entering into the contract. So, Lord Hoffman arguably tried to change the law and failed. We'll see whether he did the same with interpretation after the break. Let's take a break there, guys. I know I've run over a little bit, but I wanted to get through interpretation. So we'll come back at 12 past 12, and we'll look at interpretation. And any questions you might have. Okay, everyone, let's get to it. Last thing to say about implication is, remember I said last week that there were also the terms might be implied in by law. And I've got a couple of examples on the slides where, for example, in the Consumer Guarantees Act, it's very clear that actually you can't contract out of it or certain sections of it. So those obligations contained with the Consumer Guarantees Act would be implied into any contract caught by the Consumer Guarantees Act, mainly, surprisingly, consumer contracts. And similarly, under the CCLA 273, you don't need to know the details, but it's just an example. When you are carrying goods, there is an implied term under that section. But it can be that one can be contracted out of. Okay, so there's all sorts of different common law and statutory rules that will apply if the contract is silent. But it can, like other implied terms, be overruled by the express wording of the contract, except if, like in the Consumer Guarantees Act, it's a statutory requirement that cannot be contracted out of, which obviously for consumer protection contracts, there's a good reason why you can't contract out of that. Because the whole point is to protect weaker parties who can't protect themselves through normal contract law. Okay, just a couple of examples, and just to remember that as well. Okay, before we move on to interpretation, are there any questions at all about that? Implication. It's a high threshold. You look at what the contract provides for, if there are any gaps, and then the question of, should you do anything about those gaps? Is it necessary to imply a term in? Okay. Interpretation. Remember when we looked at incorporation last week? We started off by discussing the parole evidence rule. The idea that when you have a written contract, you could not amend or delete or contradict it by bringing in evidence from outside the contract itself. And that one of the great reasons to have the parole evidence, or one of the great benefits, was efficiency, certainty, and also to reduce disputes about interpretation. The first case I've given you in the readings on interpretation is not a good statement of the current law, but it is an example of the traditional parole evidence approach to interpretation, and particularly the reasoning for it. When parties reach an agreement and reduce it to writing, then they can't vary that writing or bring in evidence from outside it to contradict that written agreement. The question always is the writing meant to be the parties' agreement? But assuming it is, then giving effect to the writing, the court said, is merely giving effect to the parties' intention. Why? Because the whole point, the court said, of reducing a contract to a written document is to have a single source of the contract and to do away with any arguments that might arise about what positions they took during negotiations beforehand, or any misunderstandings that arose from what might be quite protracted negotiations. The whole point of the written document is to do away with all of that. We don't need to worry about what happened before. We've just got the document itself. So don't bring up any evidence about what was said in negotiations or what the parties, how they negotiated beforehand. You just look at the contract itself, and that is certain, and that is efficient. Which means that the words of the document are to be interpreted simply according to the words of the document. You just take the clear words and you apply them. Fine, easy. Only if you can show some fraud or mistake in recording the contract could you defend yourself against the written document. And so that's where doctrines like non est factum and rectification might come in. So, Your Honour, I'm not trying to amend this document or say this wasn't... With rectification, you are trying to amend the document. You're saying that I was mistaken to be unconscionable to enforce this contract as written. And non est factum, you're saying I just didn't consent to this, as we've already talked about. But aside from that, you just apply the written words of the document. Fast forward 90 years and we get an example of this in New Zealand, Melanesian Mission Trust, which is a New Zealand decision but at the Privy Council, which sets out this traditional approach that really existed up until the early 90s, which is to look at the intention of the parties based upon the words of the agreement and to give the ordinary meaning to those words as far as you can do so. So if the meaning is clear and unambiguous, you give effect to those words. You should not search for an ambiguity, but if there is an ambiguity, then and only then can you go outside the words of the document to figure out which of the multiple meanings of the word should, or the phrase or the clause, should be taken. When figuring out the plain meaning of the words, then you can look at the entire document. So you don't just have to focus on the one clause. You can put the clause within the entire document as a whole and the context in which the words are used in the document to determine their plain meaning. But the point is that the words are still king. And you give the plain meaning to those words and you don't worry about anything else. The only way you'd go into extraneous evidence is if there is an ambiguity in the words themselves that just cannot be determined within the contract itself. Then and only then do you go outside the words of the document. So that is the traditional approach. And it is no longer the approach in either the UK nor New Zealand. And in fact, you can see how far we've come when we turn to Bathurst at the end. In about 30 years, we've just completely blown past that understanding of contractual interpretation. And the real sea change, I'm going to ignore Benjamin developments, but even then in Benjamin developments, I'll just tell you a little anecdote to give you an idea of what's talking about. We started to open up what evidence could be brought in to determine the interpretation of a contract. And in this case, one of our previous professors here, Francis Dawson, worked on this case. And he said they had an entire room in their offices full of boxes of written material, which was evidence that they put to the court to determine what the contract meant, or what part of the contract meant. And this is not even the full-blown modern approach to interpretation. But even then, when you go outside the words of the document, you open up the, I don't want to say the floodgates because it's got a meaning in me, but it open up the floodgates to all sorts of evidence being put forward to show what the parties intended when they wrote those words. And that has obvious implications for the cost and the length of any dispute about contractual interpretation, let alone any third parties being able to figure out what on earth this contract means, because they wouldn't have access to those boxes and boxes of evidence. So anyway, just a practical idea of what this actually means. So I'm not going to go through Benjamin developments. You can read it yourself. ICS, though, is where things really start happening. And again, this is Lord Hoffman, which we came across in AG in Belize. It's sometimes described as a new approach, but to be fair, it doesn't start from this case. There are cases preceding this, like Pren and Reardon Smith, that are cited in ICS, where the courts start moving away from what's known as a textual approach, just looking at the text itself, to a contextual approach, the broader context. But what we can say is that ICS really set the ball rolling on this more contextual, or sometimes it's known as a purposive approach, looking at the purpose, the objective purpose of the parties, which does bring with it the danger not only of greater cost and complexity of litigation, but the danger of the contracts being rewritten by the courts. And Lord Hoffman based his argument on this statement here, that we should interpret contractual documents in the same way as any serious utterance could be interpreted in everyday life. So when you hear a serious utterance, how do you interpret it? Well, utterance proposes oral words, so we'll keep it to oral words. What sort of things do you look at when you are figuring out what's the serious utterance that's given to you means? What will you look at? What will you try to figure out what this means? So the words used is probably a good start. What else would you look at? Yeah. Fantastic. And by context, absolutely anything. In what context is this being made? How is this being uttered? What relationship background are there between the parties? What inflection on the voice is being used? Etc., etc. Can anyone, there is one, a lot of ink has been spilt about this half sentence from Lord Hoffman. Can anyone think of an obvious rejoinder to the idea that contracts are just like any serious utterance in everyday life? Yeah. They're meant to be legally binding, yeah. So not every serious utterance is meant to be legally binding. So, okay, so what does that do to your way you interpret it?
Like something that's taken a lot more seriously than a serious utterance per se.
Okay, fantastic. Okay, so there is a higher... People should be put on guard when they're making a contract, and therefore should be, it should be harder to get round their words. I think that's right. But also to be binding, what does a contract need to be? What's the difference between a serious utterance and a contract? Not just that it's legally binding, but that is a key importance. How is a contract... Oh, sorry, yeah.
If there's a serious utterance, it doesn't necessarily mean that there's a reciprocal relationship.
Yeah. A serious utterance is a wholly one-sided thing. A contract, by its very definition, a simple contract, by its very definition, must be reciprocal. A written document is not like any serious utterance. Sorry, a written contractual document is not like any serious utterance. It is the product of a negotiation between two parties. A serious utterance in everyday life is just someone deciding what they would like to say, albeit seriously. A contract is the particularly extremely complicated contracts like was an ICS, is the product of much negotiation by the parties, which has taken a lot of give and take, which has taken various forms, and which is finally reduced to writing. Remember, what did they say in the first case we looked at, Gordon and McGregor, about 20 minutes ago? The point of the writing is to get rid of any of that previous context. And so that, at least, is one factual way I say that I would disagree with Lord Hoffman there. But because he treats it the same as any serious utterance in everyday life, he says that the way in which we interpret a contractual document is objective. We must read the document as reasonable people at the time that the contract was entered into, with all the background knowledge that was reasonably available to the parties. Which is blowing the parole evidence rule out of the water. However, there are a couple of exclusions according to Lord Hoffman. Firstly, you cannot bring in any evidence of previous negotiations. So direct communications between the parties would not be, during the negotiation phase would not be relevant or not be admissible. Nor would declarations of subjective intent. So your diary entry the night that you enter into the contract saying this is what I intend by this document that's wholly subjective would not be good evidence that Lord Hoffman would allow. Where he also goes further than the approach we saw in Melanesian. Remember in Melanesian they said we could only go outside the words of the document where there's an ambiguity. On the face of it, an ambiguity. Lord Hoffman goes further. He says the background can indeed help with ambiguity, but it can also show that an unambiguous word was actually wrongly used. So you can go to background for every single word in the agreement. Because how do you know if it's wrong or not unless you've looked at the background? Now, he does qualify this and says, look, we don't easily expect people to make mistakes in formal documents because they're legally binding, because they're the product of negotiation. But if the wrong words were used, then the courts will not slavishly follow them. The immediate question is, well, what does this do or how does this interact with the equitable doctrine of rectification, which is designed to help parties where the wrong word has been used. We start with the words, we give them their conventional meaning, unless one party can bring evidence from the background to show that the conventional meaning should not prevail. So again, what does this do? It allows disputes about the meaning of otherwise clear words to potentially be exceptionally long, exceptionally detailed, and exceptionally complex. Because even if the evidence is eventually rejected, the court and the lawyers arguing it have to sift through all of it that you could bring in. That's where you get rooms of boxes of evidence to figure out what this contract means. But ICS goes from you can only look at context when there's a clear where there's an obvious ambiguity in the text itself, to you can use background context to figure out the meaning of the entire document, all the words in it, whether or not there's an ambiguity. So, yeah, that's quite a lot. But you can't bring in previous negotiations or declarations of subjective intent. Okay, well, how did New Zealand take this? Well, there's Chartbrook. That was the other case. I'm not going to go through this as well, but Chartbrook is the other Lord Hoffman case around the same time. He's mainly looking at pre-contractual negotiations. You can look at that for yourself. I'm not going to look at it now. I'm also, you'll be thankful about this, I'm not going to look at, in detail, Vector Gas. This was the leading New Zealand Supreme Court case up until recently. It's been superseded. It's one of those cases where you've got to make a matrix and put all the judges' names up the top and then like all the issues down the bottom and then make a matrix of which judge decided which on which issue. It's all over the place. It brings in estoppel by convention and just all sorts of stuff. It's It's optional, so you can knock yourself out. Blah, blah, blah. Take away that. The New Zealand Supreme Court wasn't unanimous. Okay. Firm PI1 Limited. Again, well, not again, but like many disasters, there was a lot of contract law arising from the Christchurch earthquakes of 2011, mainly around the interpretation of insurance policies. But what the New Zealand Supreme Court in this case confirmed was essentially that ICS was the law of New Zealand. That the general approach to interpretation is to find out what the meaning would convey to a reasonable person with all the background knowledge which would be available to the parties at the time that they entered into the contract. And that the context and background of the case informs the meaning, and there is no need for ambiguity to look at this context. But then the court does give a nod to the parole evidence rule. When interpreting a document, you have to remember that the writing is entered into at the end of a negotiation process and is designed to give certainty to the parties. So we shouldn't lightly overturn that. But of course, there is no certainty given because any dispute will still need to go through the courts, sifting through all that background material. The context also includes that when the parties entered into the contract, they may or may not have been aware, depending on what the contract was, that it would be relied on by third parties, banks, for example. And if that is the case, then that particular contract should be read with the circumstances only known by third parties at the time. So you limit the amount of knowledge that a reasonable person would read it, because when the parties entered into it, they intended it to be relied upon by third parties. And that the text is centrally important. The ordinary and natural meaning of words are powerful, but they're not conclusive indication of what the parties meant. You should have regard to the commercial purpose and structure of the parties' bargain. And if the natural and ordinary meaning results in something that's commercially absurd, then that is a good reason to try and read the contract or interpret the contract a different way. Why? Because the parties wouldn't have intended it. So commercial absurdity is a good reason to re-look at the interpretation. However, commercial uncertainty, the court says, is not merely that one party or the other is disadvantaged. It's beyond that. Where the line is drawn is hard to say, but we'll tell you when we get there. Furthermore, firm PI1 makes a good qualification or warning to future judges that judges are not always, or I would argue not often, best placed to hold what a commercially absurd result actually is. Sometimes judges have commercial experience, often they don't. In fact, there is an argument to say that we don't have enough judges with commercial and contract experience on the bench, but that's another argument for another day. And even those who have practiced in commercial law, that's not the same as actually having commercial experience and having to enter into these deals and putting your money on the line. So the court is right to warn about over-egging a commercially absurd result. It should only be reached in the most obvious and extreme of cases. And with that warning, that's why I've included this case, Arnold and Britton, where the court refused to reinterpret the clear words of a contract, even though it was argued that the clear words reached a commercially absurd result. And the contract is relatively straightforward. It was a 99-year lease on chalets in a holiday park in Wales. I don't know why I've got the sun shining, but apparently it's from Wales. And part of the holiday chalet lease was you had to pay for the upkeep of the grounds. And the first year, that upkeep was £90. And then there was a clause providing a formula for that upkeep in subsequent years. And that formula was plus 10% per year. And so about halfway through the 99 years, some of these tenants of these chalets sought to reinterpret the wording of that clause, because they said the clear meaning of £90 compounding at 10% per year is just would result in a commercially absurd result. I think the final year of the lease, they'd be paying something like £750,000 in upkeep each. And they said that is absurd, and therefore we should reinterpret the contract. I'll just show you. They don't actually have it in the judgment itself, but paragraph 5 effectively provides for what it would be. So they're trying to argue it's commercially absurd. And instead they argued, this is all what I've just said, instead they argued the clause should be read as a maximum amount only. So essentially we will agree to a reasonable amount of upkeep capped at £90 per year plus 10% for every year that we've compounding for every year that we've been in tenancy. The problem with that is that's not what the words of the contract said. It specifically said you will pay for the upkeep at £90 plus 10%. So could they reinterpret this contract based on the idea that the result would be commercially absurd? 15 has the general approach to interpretation, which again is what a reasonable person, having all the background knowledge which would be available at the time of contracting, would have understood the language to mean. And determining that, you look at the natural and ordinary meaning of the clause itself, any other relevant provisions in the contract, the overall purpose of the contract and the clause within that contract, the facts or circumstances known or assumed by the parties at the time, commercial common sense, which is where this one comes in, but you disregard subjective evidence of one party's intention. The Dear Diary entries are not good evidence of intention. So, what about commercial common sense? This is clearly commercially absurd, argued the plaintiffs, and therefore we should reinterpret this document. And the court again says you have to be very careful and slow to rewrite a contract because you don't think it makes commercial common sense. Remember, the parties control the language of the contract. Indeed, it's their only time that they get to control their obligations, is by writing down them in the words of the document. The parties cannot control what a court many years later thinks is contractual commercial sense. And the more clear the term, the less likely the courts will be to depart from that plain meaning. And again, it's the commercial common sense at the time the contract was entered into, not many years later when it turns out to have been, in fact, a bad bargain for one party. The court should not have saved someone from an imprudent or ill-advised bargain. So you need to look only at the facts known or reasonably available at the time for both parties. Okay, what about this clause? Well, the clause is quite clear. And the reason for it, there are good reasons for it. One is that there was no way for the parties to dispute what the amount owed was in any particular year. It's an easy, calculable amount. So you don't need to argue about what a reasonable proportion of upkeep was. It's just £90 compounded every year at 10%. Furthermore, these contracts were entered into in the late 70s, early 80s. Inflation was running higher than 10% at the time. Therefore, there were strong grounds for someone to try and inflation-proof the amount of upkeep needed. To rewrite this, therefore, as a maximum would be to depart from the plain meaning and to insert words which aren't there. Furthermore, to argue that there was a proportionate sum or a reasonable sum based on each chalet's proportion is entirely the argument which this clause is designed to avoid. It is not inconceivable at the time that the parties would agree to this increase. Again, just look at the rate of inflation in the late 70s, early 80s. Furthermore, this can be seen as a gamble on inflation. If inflation is less than 10% a year, then the owner getting paid wins. But if inflation is more than 10% a year, then the owner getting paid loses. But the point is, it's a gamble that cuts both ways. Inflation was high at the start. It has subsequently been low. But we've still got 50 years, 60 years left to run at the time of contract on this 99-year lease. Who knows what inflation will do in the future? So maybe £750,000 a year looks crazy from 2015 when this judgment was given. But in 2070, £750,000 might not be what it used to be. Who knows what inflation will do? This is a clause that is not against commercial common sense, even if it looks like one party is getting the bad end of the stick, at least at the moment. There's no principle of inflation which allows the court to rewrite the contract simply because things didn't work out as the parties expected. So, commercial common sense. It is a way in which the courts can reinterpret the document, i.e. rewrite the clear words of the contract. But, as we see in Arnold and Britain, the courts, and we also saw in Firm PI, the courts should be slow to do so. It has to be really obvious. And a clause saying 10% a year for 99 years increase was not commercially absurd at the time it was entered into. Okay. The leading New Zealand case is Bathurst Resources, 2021, Supreme Court. And where this case goes even further than ICS is that it effectively says that contractual interpretation is a question of, or all these cases are a question of evidence. The parole evidence rule was specifically about evidence, what evidence you can bring in. ICS expanded that evidence while still disallowing subjective intention or pre-contractual negotiations. Victor was looking at post-contractual evidence, like what the parties did post-entering into the contract, and whether that's relevant. What Bathurst Resources says is, look, we're overthinking this. The question is a question of evidence. So therefore, just like any other dispute in law, let's have a look at the Evidence Act, which makes sense. And essentially, the test for evidence to be brought in to determine what a contract is under Bathurst Resources is simply the same test for any other type of evidence in law, as set out in section 7 and 8 of the of the Evidence Act. Okay. So the Supreme Court makes clear that interpretation is an evidence law question. What evidence is admissible under the Evidence Act? It's not a question about contract law really at all. So the exclusion rules to say that this evidence is excluded as a matter of law, for example, pre-contractual negotiations, that is no longer part of New Zealand law. There are no prima facie exclusions. Any evidence is able to be brought in if it has the tendency to prove the thing that you're setting out to prove. That is the meaning of the document. And as long as it's not unfairly prejudicial or would needlessly prolong the proceeding under Section 8. But if it tends to give you evidence of the question that that the court's interested in, then it won't needlessly prolong the proceeding, it will needfully prolong the proceeding. So, the only exclusion after this is undisclosed subjective intention prior to the contract. I.e., dear diary, I'm about to enter into this contract, this is what I think it means. That evidence would not be admissible. Why? Not as a rule of law, but simply because it's not relevant. The question is not what one party thought, it's instead what the parties agreed to, what their common intention was based on all the evidence and background knowledge available to them at the time they entered into the contract. So prior negotiations are admissible as a matter of law if they can show there was a common mutual understanding as to the meaning of the contract. But often they won't be relevant because they'll have been superseded by subsequent negotiations or by the contract itself, and therefore they won't be admissible under Section 7. Similarly, evidence that the parties were using a particular word in a weird or idiosyncratic way, which is sometimes called the private dictionary rule, that they have some sort of secret language that they're using in their contract. So whenever we say black, we actually mean white. If you have evidence that that's what you actually did, then that can be brought in to show that whenever we say black, we actually mean white in this contract. What about subsequent conduct? Generally, the same approach. Will it tend to help us answer the question what the parties intended at the time they entered into this contract? So we can bring it in, but remember, often it won't be relevant to the question of what the parties intended at the time they entered into it. Or it will be self-serving. That is, they know there's a dispute, so they're going to start changing their behaviour to give evidence of what is a better interpretation of the contract for them. So, where does Bathurst Resources leave us? It leaves us with anything is available to be brought in as evidence to show what the contract meant at the time it was entered into, objectively, and the only reason any particular evidence will be excluded is because it's not relevant. So subjective intention or evidence of subjective intention which is uncommunicated is clearly not relevant to that question. It's an objective approach to interpretation. But anything else goes. So, well, that's easy. The parole evidence rule is far in the distance in our rearview mirrors at this point. We've got the everything evidence rule now, because everything is potentially evidence for determining what a contract means. This is fantastic. The proponents of this approach would argue for determining what the parties actually intended when they entered into their contract. So enforcing the party's actual objective intention is more likely under this approach. Conversely, extended litigation and costs and disputes is also likely under this approach. But according to the Supreme Court, this is what the Evidence Act says. We're not concerned, or at least we're not as concerned about those about efficiency arguments than we are about interpreting the contract correctly. The Supreme Court, those last word is actually from Local Government Mutual Fund Limited a couple of years later. Oh, sorry, 24, last year it was. Which is interesting in that it cites firm PI1, not Bathurst, really. And the relevant paragraphs are both up there, 37 and 38. The general rule is that contracts, it was an insurance contract again, are interpreted the same way as any other. Yep, that's fine. The general approach to contractual interpretation is that set out in this court's decision in firm PI1 Limited, not Bathurst. The approach is an objective one with the aim of ascertaining the meaning which the document would convey to a reasonable person, having all the background knowledge which would reasonably have been available to the parties in the situation in which they were in at the time of contract. So, Bathurst would say that's the question we're trying to figure out. Does the evidence you're seeking to lead or bring into this court tend to help us to answer that question or not? But we also have this qualification. While context is a necessary element and the focus is on interpreting the document rather than particular words, the text remains centrally important. And then it recited what it had said in firm PI. If the language at issue, construed in the context of the contract as a whole, has an ordinary and natural meaning, that will be a powerful, albeit not conclusive, indicator of what the parties meant. But the wider context may point to some interpretation other than the most obvious one, and may also assist in determining the meaning intended in cases of ambiguity or uncertainty. I've just put that in there because after we had a very wide and liberal approach to interpretation in Bathurst, there is an argument to be made that actually maybe the Supreme Court is trying to row things back a little bit and say, no, look, it's not everything goes. The contract is still the most important thing. The words are still the most important thing. And you really only need to go outside of it in certain circumstances. Watch this space. But I think we can say that interpretation in New Zealand is exceptionally liberal in that any evidence can be brought in if it tends to show what the contract would mean to reasonable parties at the time of entering into the contract. Whether or not concerns around efficiency, dispute resolution and third parties being able to rely on contracts, whether those concerns will mean that the Supreme Court will row back, as arguably they're trying to in Bathurst, in this case, local government. We will wait to see. The debate lives on, and whether you're a contextualist or a textualist when it comes to interpretation, well, I think that just really depends on which you think is more important. Reaching the party's actual agreement, objectively speaking, or ensuring that disputes and efficiency can be dealt with efficiently. Okay, everyone, what a whirlwind, 2 hours. So let's have a recap on Wednesday. Bring your questions to me on Wednesday, and we'll go through question 4 from last year. See you then. I don't think so, but I think he might. It's just interesting enough.